Bill C-15, an act to amend the Controlled Drugs and Substances Act and to make related and consequential amendments to other acts. And we now have the privilege of welcoming as witnesses, as individuals, Mr. John Conroy, who's a lawyer, and Madame Lynn Beauchesne, who is a professor at the University of Ottawa, and representing the organization Law Enforcement Against Prohibition, Mr. David Bratzer. Welcome to you all. Thank you very much for being here. Mr. Bratzer, the floor is yours.
Thank you, Madam Chair. And thank your honourable senators for having me here today. I am a constable with the Victoria Police Department, but I am here today representing LEAP, Law Enforcement Against Prohibition. LEAP is an international non-profit organization of cops, judges, prosecutors, prison wardens who want to gradually legalize and regulate drugs. I don't support or encourage drug abuse or breaking the law. However, after decades of heavy enforcement, we see that in the United States, in Canada, and around the world, our drug laws have failed to keep illegal drugs out of the hands of our children. I'm here off duty, and what I say does not represent the official views of my police department. However, my experiences as a police officer certainly inform my testimony today. I've been on the job for 4 years now, and before that I was a jail guard in city cells for 2 years.
What city?
Victoria Police Department in British Columbia. I'm not an expert in drug policy or psychiatry, nor am I a social worker, a counselor, a medical doctor, or a scientist. As my colleague Walter McKay has said, if police officers are qualified to comment on anything, it lies merely in the area of arresting criminals and helping people in immediate distress. I've been speaking publicly about drug policy for 1 year now, and at the end of this year, I've come to the conclusion that Canadian law enforcement agencies are obsessed with chasing drugs. And yet our professional understanding of basic drug policy issues within law enforcement is very low. Therefore, I would urge the committee to place more weight on the testimony of real experts, some of whom have already appeared before the committee, rather than law enforcement officers such as myself. And before adding new legislation, we must also consider what our current drug laws have done to the vital profession of policing. In my experience, it has divided officers from the communities we serve. It has alienated us from young people, sent our call loads through the roof, placed huge financial strains on our budgets. It has resulted in drug-related police corruption, even though the overwhelming majority of officers are good, honorable men and women. And sometimes officers have been injured or killed while executing our drug laws. I have reviewed Bill C-15 in its current form. I consider it a small step in the wrong direction. And here are a few of my anticipated outcomes for this bill. First and foremost, law enforcement will direct more energy into drug enforcement because it's natural for officers to focus on investigations where they perceive they will gain the greatest rewards for their efforts. There is finite investigative capacity within Canadian law enforcement. So it matters what police officers choose to investigate. The creation of mandatory minimum sentences in Bill C-15 provides incentives for police officers to investigate drug offenses rather than sexual offenses, bank robberies, internet child luring, identity theft, and other crimes that do not have minimum sentences. I believe this bill will cast a wide net against marijuana growers, whether the grows are large or small, whether they are indoor or outdoor, whether there are children present, whether they are for personal use, whether there are hazards, legitimate, genuine hazards present or not. I believe that individuals who do not require treatment will seek treatment through a drug treatment court program simply in order to avoid the mandatory minimum sentence. This will reduce opportunities for those who do genuinely want and need treatment. I believe that provisions regarding criminal organizations will be difficult to prosecute and rarely used, owing to the inherent difficulty of proving the existence of an organized crime group in a court of law. I believe this bill will drive more drugs into the hands of youth by encouraging adults to recruit young people as drug dealers. In my job, I routinely see young people caught selling cocaine and other drugs in the worst parts of my city. The penalties for young people caught selling drugs are rightfully less severe than for adults. Therefore, this bill will likely encourage dealers to approach vulnerable teenagers and manipulate them into the drug trade. And I know that this bill has provisions for people who use the services of minors in the commission of an offense. But let's be honest, how are we going to prosecute those people? Are you going to take a 16-year-old Aboriginal kid that grew up in some housing project, ask him to get on the witness stand and testify against a mid-level drug dealer? You know, even if you can get this young person to agree, once he does testify, it seems to me you're essentially putting that person in danger. You're basically signing their death warrant. I believe traffickers who are victims of drug rips and home invasions will be less likely to call the police, knowing that they may face a mandatory minimum sentence. And this is important because they will be more likely to take retaliation into their own hands, resulting in spiraling violence and bloodshed across Canada. I believe that the brightest and most cunning drug dealers will enter into relationships with law enforcement agencies as confidential informants. They will use this legislation to imprison their competition and strengthen their own positions within the black market. Lastly, and perhaps most importantly, I believe that the flow of illegal drugs to Canadian consumers will not stop, and the black market will continue to lack regulations controlling price, purity, safety, and access. So my views on this bill are simple. C-15 is incompatible with law enforcement against prohibition's position on drug policy, and frankly, there is no way to reconcile the two views. However, if some form of this bill is going to pass, I would encourage you to strengthen the reporting provision. As you know, Section 4 of Bill C-15 introduces a provision that requires a review of the Controlled Drugs and Substances Act after 2 years, as well as a report to Parliament. 2 years is a long time in politics, but it is a short time in the criminal justice system. By the end of the first 2 years, the effects of Bill C-15 will not be clear. Some criminal trials will not even be completed. Many mandatory minimum sentences will have begun but not ended. New prisons will not be built yet. We will not have a good idea of the true costs involved, nor of the impact, if any, on cross-border smuggling, crime rates, drug use rates, overdose rates, or any of the other issues this legislation may affect. The numbers at the end of the first 2 years may be deceptively low. It therefore may be valuable for lawmakers to consider additional reviews and reports at the 4-year mark, the 7-year mark, and the 10-year mark for a total monitoring period of 10 years. Honourable Senators, thank you for your time.
Thank you very much, Mr. Bratzer. Professor Beauchesne?